Hello and welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by livelaw. I'm your host Syed Amir Hussain and I'm here to take you through the most significant updates from this week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. Remember, for a more in-depth understanding, do log in to our website at www.livelaw.in. So let's dive into the headlines. This week, the Delhi High Court stayed the bail granted to Delhi Chief Minister Arvind Kejriwal in the Delhi liquor policy case. The Rouse Avenue Court initially granted Kejriwal bail, citing a lack of direct evidence from the Enforcement Directorate regarding the proceeds of crime. The court also questioned the credibility of ED's approvers and noted that Kejriwal was neither named in the CBI case nor the ECIR. This order granting bail was pronounced at 8 p.m. on Thursday. However, the ED quickly moved to the Delhi High Court, arguing that the bail order was perverse and contrary to the mandate of Section 45 of the PMLA. Allowing the central agency's request for an urgent listing, the High Court heard the challenge on the very next day, that is Friday. Among other things, Additional Solicitor General S.V. Raju criticized the trial judge for not allowing ED a full opportunity to present its case and contested the claim that there was no direct evidence. Senior advocate Dr. Abhishek Manu Singhvi, representing Kejriwal, countered that the accused should not be kept in jail indefinitely without substantial evidence. The senior counsel also objected to what he described as the Enforcement Directorate attempting to malign the trial judge, insisting that the central agency was not denied any opportunity to present its case. In support of this, he pointed out that out of a total of 5 hours, the ED's arguments before the trial court went on for 3 hours and 45 minutes. He also vehemently opposed the stay, saying that it would amount to a cancellation of bail. However, after hearing the arguments, the vacation bench comprising Justice Sudhir Kumar Jain and Justice Ravindra Dudeja ultimately decided to reserve its order and stay the trial court's bail order until the pronouncement is made on the ED stay application. In the latest development relating to the ongoing NEET UG 2024 controversy, the Supreme Court this week addressed another petition concerning the results of the examination conducted by the National Testing Agency. This petition was heard by a vacation bench of Justice Vikram Nath and Justice S.V.N. Bhatti. Other petitions have highlighted issues such as alleged paper leaks, malpractices and controversial grace marks given to certain candidates. In the present petition, the petitioners emphasized the importance of the investigation's status ahead of July 6 counseling sessions. During the hearing, the court stressed the need for utmost diligence in conducting the NEET exams, highlighting the severe consequences of minimal negligence considering the hard work candidates put in. Even 0.001% negligence in conducting the NEET exams be looked into with all seriousness, the court remarked. Justice Bhatti also said that fraudulent candidates who become doctors pose significant societal risks. He further urged the National Testing Agency to proactively acknowledge and rectify any mistakes to maintain public confidence. The union's counsel submitted that the centre's recent decision to revoke grace marks of 1563 students indicated that the authorities were responsive to the concerns raised by candidates. Ultimately, the bench tagged this matter with other pending petitions, which have been scheduled to be heard on July 8th. This week, the Rajasthan government informed the Supreme Court of its plans to introduce an anti-conversion law. This update came in response to a 2022 petition by a BJP member which sought stringent measures against fraudulent religious conversions. The court had previously tagged similar PILs challenging anti-conversion laws in the states like Uttar Pradesh, Madhya Pradesh, Haryana and Gujarat. In November 2022, Justice M.R. Shah and Justice Hema Kohli had observed that forceful religious conversions, if true, were a serious issue which could affect the security of the nation and sought responses from the centre and the states. Rajasthan's affidavit stated that while the state currently lacks specific litigation on religious conversions, it is actively working on a new law. Until then, Rajasthan will adhere strictly to existing laws and Supreme Court guidelines. In related news, recently the Supreme Court has observed that parts of UP's anti-conversion law may violate Article 25 of the Constitution, which guarantees religious freedom. The Supreme Court has announced plans to hold a special Lok Adalat from 29th July to August 3rd to facilitate amicable settlements in pending cases. This initiative commemorates the 75th anniversary of the Supreme Court's establishment and reflects its commitment to accessible and efficient justice for all. The special Lok Adalat will address cases with potential for settlement, including matrimonial and property disputes, motor accident claims, land acquisition compensation, and service and labor issues. By organizing this Lok Adalat, the Supreme Court aims to expedite case resolution and reduce the burden of the judiciary, ensuring timely justice for the public. In a significant decision this week, the Calcutta High Court directed the West Bengal government to implement a 1% reservation for transgender persons in public employment. This directive aligns with the Supreme Court's NALSA guidelines, which recognize transgender persons as socially and educationally backward, and directed the state and the union governments to carve out reservations for them to protect their rights. The case before the Calcutta High Court was brought by a transgender person who, despite passing teachers' eligibility test twice, was not called for interviews. Justice Rajshekhar Mantha highlighted the need for the state's reservation policy to comply with the Supreme Court's order. Accordingly, the court instructed the West Bengal Board of Primary Education to arrange an interview and counseling for the petitioner, marking a significant step towards ensuring equal employment opportunities for transgender individuals in the state. This week, the Karnataka High Court granted anticipatory bail to Bhavani Revanna, mother of former MP Prajwal Revanna, in a kidnapping case. The prosecution has accused Bhavani of orchestrating the abduction to protect her son, who faces sexual assault charges. The special public prosecutor argued for revoking her interim bail due to non-cooperation with the investigation. However, Justice Krishna S. Dikshit noted that Bhavani had answered all 85 questions posed to her, emphasizing that the police cannot expect answers to align with their narrative. Bhavani is prohibited from entering Mysore and Hassan districts except for investigation purposes. The court also cautioned against media trials, highlighting the potential impact on the family life of the persons involved and urging print and social media to exercise caution, especially in the case of a woman. This week, the Bombay High Court permitted the release of the film Hamare 12 on June 21, 2024, following modifications by the filmmakers. Previously, the Supreme Court had halted the film's release, deeming its teaser offensive, but left it to the Bombay High Court to take a final call on the merits of the petition. The petitioners alleged that the movie contains derogatory content towards the Islamic faith and married Muslim women. The division bench of the Bombay High Court, comprising Justice B.P. Kolabawala and Firdaus Pooniwala, however, allowed the release of the film after recording the changes to be made, to which the filmmakers have agreed. The changes include the removal of a certain dialogue and Quranic words and the addition of 2 disclaimers of 12 seconds each. The filmmakers have also committed to paying Rs 5 lakhs to a charity of the petitioner's choice. The Central Board of Film Certification has agreed to rectify the film based on these changes by June 20th. Subsequent to this, the Supreme Court dismissed as withdrawn another plea under Article 32 regarding the film Hamare 12. The court refused to entertain the petition, pointing out that it had dealt with another petition raising similar issues and left it to the Bombay High Court to ultimately decide the case on merits. However, the petitioner was granted liberty to file a fresh petition challenging the Bombay High Court order. This week, the Gujarat High Court directed the state government to form a high-level committee to investigate the Rajkot gaming zone fire, which tragically killed 27 people, including 9 children. The inquiry aims to determine the culpability of Rajkot Municipal Corporation officers, including municipal commissioners, since the gaming zone's inception. Chief Justice Sunita Agarwal and Justice Pranav Trivedi emphasized the need for accountability and consequences for any negligent officials. The court noted inaction by the Rajkot Municipal Corporation as the gaming zone's unauthorized construction was only addressed years after its development. The gaming zone in question was developed in June 2021 and the owners applied for regularization of the constructions under the Gujarat Regularization of Unauthorized Development Act 3 years later. A public interest litigation has been filed in the Allahabad High Court to set aside Congress leader Rahul Gandhi's election as an MP from Raebareli on the ground that he is a British citizen. Filed by Karnataka resident S. Vignesh Shishir, the plea seeks to disqualify Gandhi from holding office until the citizenship issue is resolved. Further, the petition argued that the Gandhi's conviction and sentence in the Modi surname defamation case, although stayed by the Supreme Court, disentitled him from contesting the elections because of Article 102 of the Constitution read with Section 8, Subsection 3 of the Representation of People Act 1951. Chief Justice Pritinkar Divakar issued notices to the Election Commission and Rahul Gandhi, setting a hearing for June 25th. In 2019, the Supreme Court dismissed the plea by 2 private persons to restrain Gandhi from contesting to the 2019 general election until the determination of the dual citizenship issue upon his supposedly procuring British citizenship. And that's a wrap for this week's Legal News Roundup. Before we bid adieu, the entire Live Law team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audio-video format, we rely on your support. Here's how you can help. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates and colleagues. Make sure you're subscribed to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments below and hit that bell icon to stay updated with our latest releases. Don't forget to visit our website at www.livelaw.in for in-depth reports and analysis. Not only this, but the Live Law channel offers memberships for only ₹89 per month. Become a part of LL supporters today to access exclusive perks such as loyalty badges next to your name in the comments and live chat, priority reply to comments, and for our student pass audience, early access to explainers and legal updates. I am your host Syed Amir Hussain, and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged, and stay tuned to Live Law. Thank you for watching.